Well, greetings everyone. This week we are going to be studying the United States Constitution. There are two videos on this. One is going to cover the founding and some of the politics of the Constitution, and we'll get a ways into the contents of it. And then the second video is going to finish up with the contents of the Constitution. So I'll go through the sections here in just a minute, but main thing here is that we're connecting the Constitution, the terms and provisions of the Constitution, with the times in which the Constitution was written. And in order to understand what's in the Constitution and why it isn't, it wasn't delivered from, it isn't a holy document that was delivered by the supreme being of the universe or any of this stuff. It was written by human beings. And it was written by people at a time, a particular time and place in history, to respond to their concerns. Which means that this is now our Constitution, and if it doesn't suit our purposes, we need to change it. And there are provisions in the Constitution for amendment, which we will talk about. So don't ever take the Constitution as some sort of sacred document that can't be changed. It has all sorts of things in it that were written for a particular time, and that don't really, if they don't suit us, we need to think about how they should be changed. So what do I mean? Well, by the structure of the society and so forth, at that time, we're talking now about pre-revolutionary colonial America. So the revolution started in 1775. Independence was declared in 1776. And so in the decades before that, in the 1750s and so forth, there was a class structure in that society. Everybody was not equal, not the same. And the way the society was structured influenced our first governing document as a nation, which was the Articles of Confederation. And quick overview would be that the Articles of Confederation, our first constitution, so to speak, empowered the less wealthy sectors of society. The Articles were supported by basically radicals, democratic radicals, who believed in small d, democratic principles. I don't mean there was no Democratic Party, but I mean they believed in democracy. Elites, colonial elites, and later elites in the new nation, the new U.S., were unhappy with this situation, and they did not like governing the way the Articles of Confederation worked, and so they scrapped the Articles entirely and drafted a new constitution that put them back in power. That's the overarching political background to it. So what do I mean by class structure? This is before the Revolution. Before the Revolution, at the top of the society, there were educated and talented, well-educated people with lots of background and so-called culture, whatever they wanted to call it. They were the elites. They were planters in the South, people who owned plantations. They were lawyers. They were bankers, and they saw themselves as the best people in the society. Now, you and I probably would not share that opinion that they were the best people, but that is certainly the way they saw themselves. And then there was this other group called the Royalists, and they were the people who had received large land grants and certain jobs from the king. I'll talk a bit more about them. They were part of the elite too. And then there was kind of an emerging middle class of successful farmers, shopkeepers, independent tradespeople, printers, and people who made, barrels and clothing and that sort of thing. And kind of below them would be the people who owned small patches of land, the freeholders, people who were fishing, people who cut lumber, worked on the docks, laborers essentially. And then below them we have the indentured servants and tenant farmers who did not own land, and in some cases who were bound to labor for other people for terms of years. Many people earned their passage to the New World by basically signing themselves up for indentured servitude for a term of years. And then below that were the slaves who had no legal rights at all. Enslaved people had no legal rights and were viewed as property. And that, of course, becomes one of the main controversies in the drafting of the Constitution and the new Republic. So how did that structure get disrupted and lead to new governing structures? Well, it really started in the 1760s. I won't go through all the history of this, but we were a colony of the United Kingdom, and they engaged in a prolonged war with the French. Our end of it we called the French and Indian War, but it was actually a much larger war than that. It went on for at least 9 years. And the British did prevail for the most part in that war, but it cost them a tremendous amount of money. And a movement emerged in Parliament and in the Crown to increase taxation on the colonies, in the 13 colonies. And these provisions were called the Sugar Act, the Stamp Act. There were a number of them. The colonial elites, that is the merchants and planters and lawyers, were opposed to this. And that's when they came up with this slogan, taxation without representation, because they did not have representation in the British Parliament, which is who imposed the taxes. This converged with the activity of a group of radicals. So these were the people who wanted more democracy. They were ideological. The colonial elites were driven primarily by their own economic self-interest. They didn't want to be taxed. But the radicals really wanted greater electoral democracy, which was a radical concept at that time. And they staged the Boston Tea Party. This was kind of a joint operation. And the Boston Tea Party was a protest against a bill that gave a monopoly on the tea trade to the British East India Company and cut out the local colonial merchants out of that tea trade, which is very lucrative. There were boycotts, there were other things. So just understand that the radicals were trying to get democratic reform. The elites, the wealthy, simply wanted tax breaks. And they had an alliance of convenience, so to speak, in opposition to British policy. And what happened was that the British responded to all these protests with a tremendous crackdown. I mean, they really did become quite harsh in their treatment of the colonists, and put down, anyone who protested. There was the Boston Massacre, in which people were shot to death, and so forth. You've probably heard this story previously, but understand what happened here was the British response shifted people's goals away from tax reform or democratic reform to, well, we can't get anywhere without independence. And it began to shift movement from reform to saying we need to break away from the United Kingdom. That was a big, big step. But the British kind of... So there's a whole series of events here. I won't go through all of them, but you've read about some of these, I'm sure. The First Continental Congress, the Battle of Lexington and Concord, the Second Continental Congress, the famous pamphlet by Thomas Paine, Common Sense. But just note, it's really significant. The shooting started in April 1775, but it wasn't until 17 months later, July 4th, 1776, the colonists declared independence. And that shows you what a big step this was. I mean, it was something they weren't even ready to do, even when the shooting started. It took quite a while. Now, at that point, the Royalists left the country and lost their property. Most of them went to Canada. They were supporters of the British Crown. They were no longer popular. They left. And now the pre-colonial elite was damaged because Royalists had to leave. And now what we had left were merchants and planters, but a new group of people coming into power, these radicals that we talked about, who represented largely farming and urban artisan, middle-class type interests. And they entrenched themselves in the Continental Congress. That's the governing body of the colonies during the Revolutionary War. They controlled the flow of money to the Continental Army. And they were concerned about giving too much to the generals because they did not want a military coup. Who were the military commanders they were afraid of? Upper-class merchants and planters were the only ones who had any military officer training, George Washington being first and foremost among them. And these wealthy people were the ones who really financed the revolution through bonds. They basically made loans to the new government, and they wanted to be repaid after the revolution was over. This is a very significant mind as we look at what the provisions of the Constitution. So during the Revolutionary War, 75 to 83, Congress was very concerned about the army getting too powerful. So this is just an example of that, holding up the money. Washington's army spent a very, very hard winter at Valley Forge, in part because Congress would not release to them as much money as the generals wanted. And this is one of the things that led Washington to believe that they really needed a stronger central government. Now, one reason the Americans won their independence was because of France. And I won't go into all the details. I'm sure you've heard some of this. But the French were an important ally because they were, of course, an enemy of the United Kingdom. After the Revolution ended, during the years 81 to 89, under the Articles of Confederation, state legislatures, under the Articles, were the main policy-making institutions in the country. Congress was actually very, very weak. The state legislatures were largely responsive to the more radical interests, the more democratic interests that represented ordinary people. But the problem was they really had 13 separate state governments that were like little national governments that all wanted to have their own little state economy, and they wanted to compete with each other. The national government was very weak. It could not tax people directly. So the people if you'd lent money, if you're one of the rich people that lent money to the Continental Congress to fight the war, you're thinking, I may never get paid back. This government can't even raise money directly. It has to ask the states for money. So these merchant and planter interests were largely out of political power under the Articles, and they felt threatened by these state legislatures. They also did not want 13 small local markets. They wanted one big national. So the basic problems were they had a weak national government, no power to tax directly, no power to regulate commerce, no chief executive with enough power to implement laws. There was a president, but it was really just a presiding officer, not the kind of president we have. No national court system, and no real national control over the powers of the state to do whatever the heck. So the big picture here is that the Constitution, by many of its provisions, put the pre-revolutionary elites back in power. It did a number of things, and as we go through the terms of the Constitution, I'm going to show you that. The main point here is understand this Constitution that we have, that we act like we can't change, was written to solve certain problems that were problems in the 1780s, a long time ago. Not our problems, their problems. And, it was intended to solve the problems of the states making economic warfare on each other, basically saying, if you grow corn in Maryland, you can't sell it in Virginia, things of this sort. And the national elites were thinking, this is terrible. We need to be able to trade through the entire country without limit. They also wanted to protect their own private property rights against state legislation because state legislators were canceling debts and making it easy to go bankrupt and all sorts of things. They were doing their own foreign policy at the state level, and all the states were doing something different. There were a lot of problems with the Articles of Confederation. So what they wanted to do with the Constitution, which what they actually did, was create a national economy so that only Congress could regulate interstate commerce, meaning commerce among the states. The states could not impair each other's commerce. The national government would have real power over the economy and would control foreign policy. It would have a taxing power, and then it could pay back its bond obligations to the wealthy merchants and planters who funded the revolution. So the net effect is if the Constitution was ratified, the pre-revolutionary elites of merchants and planters would be back in power. So there was a huge battle over ratification between these economic elites who called themselves the Federalists and small farmers, artisans, and radicals who call themselves the Anti-Federalists. The Federalists won. The Federalists argued in favor of ratification of the new Constitution. A document called the Federalist Papers, which was a series of short papers put together, mainly written by Madison, Hamilton, and Jay, became the doctrine that persuaded people. They were published in newspapers. They became the first political party, the Federalist Party of Washington, Adams, etc. And the Anti-Federalists, who tried to prevent ratification but failed, wanted to preserve the Articles of Confederation that they were done away with. They became the Democrat-Republican Party of Jefferson. And interestingly, James Madison, was originally one of the Federalists, and he ended up switching sides and becoming, after the first few years of the Republic, eventually he switched sides and supported his friend Jefferson. But that was long after ratification. Now, The Constitutional Convention took place in 1787 in Philadelphia. Original purpose of it was to revise the Articles of Confederation, and they had a charter that said that's what they were going to do. And the first thing they did, instead of, was to just abandon that entirely. They said, we are here to revise the Articles of Confederation. Well, we're going to throw them right in the garbage can and completely start over. They didn't amend anything. They drafted an entirely new Constitution. Also understand, changing the Articles of Confederation, according to its own terms, required unanimous consent of all state legislatures. Well, at the Constitutional Convention, they didn't even bother with that. They said, no, we're not going to do that. We're going to say that we have an entirely new Constitution if 9 states approve it. Not 13, 9. And we're not going to let the state legislatures do it because they're too radical. We'll convene special conventions. And that's what they did. So this is, one could argue that this was something like a coup that took place. The framers were, so there were supposed to be 70, 55 attended and 39 signed it. As I said, their real motives certainly were to restore the political power, maintain social order, come up with a new document that put different people in place, in power. They had economic motives of their own. They wanted to maintain property rights. They wanted to maintain slavery in the southern states. Most of them did, or at least the Southerners did. And they wanted to make sure that they, the bondholders, got repaid. So who were the founders? Well, what we know about them is almost all of them had taken part in the Revolution, 29 in the military. Most of them were officers. They were uniformly white male property owners. Most of them had political experience in state legislatures or the Continental Congress. More than half of them were lawyers, and some of them had become judges. The rest were mostly, merchants, manufacturers, shippers, plantation owners, land speculators, bankers, etc. 25 of them owned slaves. Were about 15 were owned plantations. So we have 25 who enslaved human beings. And 15 of them who actually owned plantations. Most of them were either major landowners or quite wealthy, or both. George Washington and Robert Morris, for example, were among the richest men in the entire country. So now that's the background. That's who they were. A lot has been written about them. Charles Beard's book, An Economic Interpretation of the U.S. Constitution, goes into it in great detail. But now I'm going to begin going through the actual text of the Constitution. Now you need to know this, because this is our operating document today. I just want you to look at it with an understanding of where all these terms came from. Where these provisions came from, that they weren't given to us by the supreme being of the universe. They were written by people who were involved in enslaving human beings. I'm not saying that as a interpretive or judgmental comment. I am simply stating a fact. That is what a large part of them did. That is a fact, and needs to be taken into account when you look at the terms of the Constitution, as all these historical facts do. So we'll go through an overview, and then we'll talk about the powers of the national government. Then we will go, and this is more in the second half of this, limitations on state powers and federalism, the doctrine of federalism, separation of powers between the branches of the government, and how the Constitution is amended. So, number 1, overview. Major doctrines that are in the Constitution and that were being talked about in political literature at the time include separation of powers, the idea that a government should be broken up into basically separate departments, branches, judicial branch, executive branch, legislative branch. This is an idea that was embodied in the Constitution. Separate power. Don't unify power, but separate it. And then further divide it according to something called federalism. That is, not just splitting power between executive, legislative, and judicial, but also dividing it up between the national government and the states. Now, federalism is a critical part of the structure of the Constitution. And, most countries don't have federalism, but we do. The federal government is a government of enumerated powers, meaning the federal government can only do something if there are words in the Constitution that say that it can do those things. Whereas the state governments can do anything that is in their own constitutions, their own powers, as long as it isn't prohibited to them specifically by the Constitution. We call it reserved powers. So state governments in this country don't need to look to the U.S. Constitution to find their powers. They look at their own state constitutions. The federal government, however, has to find its powers in the Constitution or it can't do it. Every single piece of legislation that Congress passes has to be authorized by a part of the Constitution. Another important part of the deal in federalism was to preserve slavery. And they did this to secure ratification by the southern states. The southern states were not going to ratify the Constitution and join the Union unless slavery was preserved. And we know that because when slavery was threatened by the election of Abraham Lincoln in the election of 1860, southern states seceded from the Union. So we know that they would not have joined the Union in the first place. This was a deal that was made. It's a compromise that was made between North and South to bring in the southern states. Otherwise, they would have gone their way and been a separate country, apparently. Another important provision is the amendment process. Now, it is very hard to amend the U.S. Constitution, but it is there. I mentioned already the ratification section of the Constitution violated the rules that were already laid down in the Articles of Confederation. And another important thing is civil liberties and civil rights, which were added. They're not in the original Constitution. They're added afterward into something called the Bill of Rights, the first 10 amendments of the Constitution. Those were done afterward, and they were added, they were promised in order to secure ratification. And that's why they had to do that in the first Congress. So basically there's a picture kind of how things look. You have a U.S. government with certain defined powers and relationships among the three branches. We call it separation of powers. Some people call it checks and balances. And then we have state governments and the doctrines of federalism. And then we have, quote, the people, the individuals, who get certain civil liberties and rights, which are explained in the text of the Constitution. And now this is something I want to emphasize. You know, this diagram shows another arrow going left and right between state governments and the people. Point being here, the Bill of Rights originally did not limit state governments. Very important thing for you to understand. The Bill of Rights only limited the national government, and it was put there because of part of a promise that was made during ratification debates. No, if you ratify this, we promise we'll give you a Bill of Rights to protect you from this new national government. It was originally not intended to limit states at all. The 14th Amendment in the Civil War changed that. The 14th Amendment Due Process Clause gradually came to be interpreted to apply most of the Bill of Rights to the states as well. This is called selective incorporation. We will talk more about this. We're going to cover civil rights. But understand, now the Bill of Rights does protect us against the actions of state governments. But originally, it only protected us against the national government in Washington. Now, I'm not going to go through this in all sorts of detail. You've heard a lot about this, the various plans, compromises for how to structure the government. You know, the Virginia plan, there were different ideas. Representation should be based on population. The small states saying, wait a minute, states should get equal representation. And we end up with basically a compromise. House in the national legislature that is based on population, that's the House of Representatives. All districts have about the same number of people. And then we have the Senate, where all the states are equal. So a state like California, which has, 35 million people or something, has the same number of senators, 2, as the smallest states in the U.S. that have 2 senators, like Rhode Island and Wyoming, the ones with the tiniest population, Alaska, Montana, less than 1 million people, etc., as the numerous states. And here's California with 35 million, 2 senators. Here's the tiny little states, 2 senators each. So that's a compromise that was struck. The compromises on the treatment of the enslaved population are a source of great shame for the United States. And this is in the original Constitution. Now, these provisions were eventually essentially obliterated from the Constitution. They're still there, but they were invalidated by the 13th Amendment to the Constitution, passed after the Civil War, which abolished slavery completely and made it illegal. But the original Constitution, before the 13th Amendment, perpetuated the institution of slavery. It put the slave trade basically out of limit for beyond regulation for 20 years. It created something called the 3/5 Compromise, which addressed the problem of how to allocate members of the House of Representatives to the states if some of the states had enslaved people and others did not. In other words, how should the enslaved population be counted in determining the population of a state? Now, if you're Virginia, you're saying, oh, we should definitely count the slave population as individuals, because that would give them more members of the House of Representatives, and they'd have then more power to protect slavery. But northern states' representatives at the Constitutional Convention were saying, oh, no, you cannot count the enslaved population because they don't have any rights, and you say they're property, and now you want to count them. It's not fair. They shouldn't count. So they reached a compromise. They said you can count 60% of the slave population toward the number of representatives you get. So that gave the South some credit for the population, the enslaved population, but not 100%. So that's called the 3/5 Compromise. Again, these are now things that are sources of great shame for the United States of America and its history. And these are things that some people wish we didn't talk about. There are some people who like to criticize what they call critical race theory, and they don't want us to talk about these things. And there are laws being passed in some parts of the country to prevent K through 12 teachers from even talking about it, but we're going to talk about it. And so if anyone doesn't like it, they can take it up with someone. But this is a fact. These are the things that the United States did, and they are part of the original Constitution, to its enduring shame. So now let's quickly go over the structure of the Constitution. You don't have to memorize this, but I want you to understand it. There is a number of articles. Article 1 is long and detailed, and it is the article that describes the legislative branch or the legislative power. This is important because understand the way the founders intended the Constitution to work. They thought that Congress would be the first and most important branch of government, not the president. Understand? This is very clear from reading the Federalist Papers. The founders thought this country was going to be run by Congress that would give the president things to do, and the president would do what Congress told the president to do. That is not the system we currently have. We have more of a system of presidential supremacy. But the original plan was legislative supremacy. They gave all the powers of the national government to Congress. I underlined that Article 1, Section 8 enumerates the powers of the national government. Well, they're described as the powers of Congress. And so that's an interesting thing. Article 2, relatively short, describes the executive branch, which has greatly expanded, as you will learn. There's no mention here in Article 2 of the federal bureaucracy, which is in the executive branch. It was created later and put in the executive branch by Congress, but it's kind of interesting because it isn't even mentioned in the Constitution except for a few basic departments. Article 3 is the judicial branch, the federal courts. We'll have a lot to say about that. Article 4 talks about federalism. The federal relationship. The states have to respect each other's legal decisions. Citizens have to be treated equally when they go between states, and so forth. Article 5 is the process for amending the Constitution. Article 6 has a number of things in it. Section 1 is very important. It says that the federal government is responsible for the debts incurred under the Articles of Confederation. Remember paying off those bondholders? Yeah. Section 2 of Article 6 talks about the supremacy of federal law, the all-important Supremacy Clause. And Article 7 describes the ratification process. So what I've done here now I'm going to go through this you need to read this. You'll need to read this on your own, but I'm going to go through and highlight. These are the key terms. What I have highlighted here in the text, the 4,000 words of the plus of the Constitution, I've highlighted the key terms. So first, on the powers of the national government has only enumerated powers. These are things we'll probably be testing you on, meaning that the federal government has to find its powers in the text of the Constitution or by implication from the text of the Constitution. But the states have reserved powers. They don't need to find their authority to act in the text of the U.S. Constitution, and that is explained in the 10th Amendment. The 10th Amendment says the power is not delegated to the U.S. by the Constitution, nor prohibited by it to the states, are reserved to the states. In other words, like I said, federal government has to find its powers in the text of the Constitution, but all the other legitimate governing power is reserved to the states, unless it says in the Constitution you can't do this. And there are things in there that the Constitution does say states cannot do. We call it the police powers. The things the reserved powers of the states are called the police powers. It doesn't mean police officers. It means protecting the health, safety, and welfare of the people. That's what the states are supposed to be doing, protecting the health, safety, and welfare of the people. The core of the Constitution, in terms of laying out the powers of the national government, is Article 1, Section 8, the powers of Congress. Congress shall have power. And then it lays out collecting taxes, etc., paying the debts, defending the country. See, these are the powers of Congress. But we think of them now, more often than not, as the powers of the president. Borrowing money, regulating commerce. This is one of the most important powers that Congress has, the power to regulate commerce with foreign nations and among the states. That's called interstate commerce. Naturalization, money, post offices, etc. And that, look at the bottom, to constitute tribunals inferior to the Supreme Court. Congress has the power to create federal courts, which they did immediately. And on and on. I won't read all of them, but you can see these are the main powers of government. Declaring war, raising armies and navies. And very important, look at the very bottom. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So Congress doesn't just have the powers that are listed. They also have implied powers from the necessary and proper clause. They can do anything that is necessary and proper to execute the powers that we've just read. Now, this is the Commerce Clause. Gives Congress the power to make one set of rules for everyone who participates in the U.S. economy. This is a very important clause. Here's the Taxing and Spending Clause. Congress can lay and collect taxes, pay the debts of the United States, take care of its defense. The Necessary and Proper Clause, again, it was sometimes called the Elastic Clause, the one we just covered. And now we have the disgraceful parts of the Constitution where Congress decided to preserve slavery. Now, this is the last slide in this this portion. I'm about to go to the second part of this, but before I do that, please listen to this. This is very, very important. You see, because this is how Congress works, we have a bicameral or two-house national legislature. We have a House of Representatives and we have a Senate. And we've talked a bit about the Senate. In the Senate, there's no principle really of representation of individuals. The Senate represents states. So each state has 2 senators. It doesn't matter how many people they have or how few they have. Every state is equal, 2 senators. And another thing, which we'll touch on in a bit later, but I want to emphasize now, is that the senators were not chosen by the voters originally. In the original Constitution, it was not until the 20th century that we got to vote for our senators, because in the original Constitution, senators were chosen by state legislatures. think if you've been paying attention, you already know that, because this has been I've discussed this in previous videos. But understand, this is the Senate is a very much an elite organization that represents whoever originally that represented states only and not people, and that they were chosen by state legislatures. But now let's talk a bit about the House. The 3/5 compromise. This is often misunderstood. If you were a representative at the Constitutional Convention of a southern state that had enslaved people, you would want the slave population to count one for one. You would want them all to count when we are counting your population. Because the higher your population, the more representatives you get in the House. And the more representatives you have in the House of Representatives, the larger your delegation is, in other words, the more power you have, right? So what the South wanted was to have it both ways. On the one hand, they wanted their enslaved population to have no rights at all, no rights of citizenship, no right to vote, no right to even go where they wanted to go. They wanted to be allowed to treat them as property, to not pay them for their labor, to be able to do whatever they wanted, up to and including even killing them. And I mean, it was absolutely barbaric. And at the same time, when it came time to say, okay, how many people do you have so we can decide how many representatives you get in Congress, they then wanted to say, okay, well, you have to count the entire enslaved population. And the North said, no, that's not right. You can't count them. You can't deny them all the rights of citizenship and even personhood and then count them when it comes to talking about how many people you have. You don't treat them like people. And this is what led to the compromise. The compromise was you can count 3/5 of all other persons, meaning the other persons were the enslaved population. So each state could count only 3/5 or 60% of the enslaved population toward their, quote, official population for purposes of deciding how many members of Congress they got. So that benefited, it's a compromise, but it benefited the South because they got to essentially have it both ways. Then we have Article 1, Section 9. This is the protection of the slave trade that I mentioned earlier, where it says the migration or importation of such persons as any of the states shall think proper to admit shall not be prohibited before 1808. Again, the such persons thing, importation of persons that states wanted to bring in, that preserved to all the states the right to allow the importation of slaves through the year 1808. So they got a 20-year window to continue importing slaves. Now, as of 1808, Congress could prohibit the slave trade, and that is what they did. They did prohibit the slave trade after that point. But they gave them a 20-year window to continue bringing enslaved people into this country. Then Article 4, Section 2, no person held to service in one state, escaping into another, shall be discharged from such service, but shall be delivered up on claim of the party to whom such service or labor may be due. This is a protection of the states that allowed slavery, so that if an enslaved person were able to escape, let's say Virginia or Georgia, and make it into Pennsylvania or New Jersey or some state that did not allow slavery, that person was not free, because the slave owner, or what they call themselves, really own people, but that's what they thought they were doing, could go to that other state, and the other state would have to surrender the person, back into the arms of the enslaver. So when I said earlier, these are disgraceful provisions that the country's, many people at least, are deeply ashamed of. But these are parts of our history that we need to know, that this actually happened in this country. And these things that I just read to you are part of the original Constitution of the United States of America. So when people tell you that the Constitution is some sort of sacred document, please understand. In reality, This is a document that states principles, but that is really there to protect interests. And a large part of it, and some of the key provisions, are there to protect the interests of people who claim that they could own other human beings. That is an important part of the Constitution. It is one of the many compromises that were used to get it ratified. So this is an important part of our history for us to understand. And, we in this class are not going to pay attention to those who say that we are not allowed to talk about this, because we are talking about it. And that's just the way it's going to be. So this really happened, and it's a part of our history that we have to know and reckon with. Now, that'll be the end of this presentation. And the next one, I'm going to take up the powers of the national government further. And we'll talk more about the institutions of federalism and separation of powers. So that concludes this presentation.